All right, good morning. I'm Attorney Joe Pippen along with John Frazier, and we're going to do a Zoom seminar for you on Medicaid. If you can hear me okay, raise your hand, wave at me so I know the volume's good. All right, great. Good morning, everyone.
Good morning.
Good morning.
So Medicaid is a very important topic. Whether you might have a loved one in a nursing home, you might have a family member in a nursing home, you might have a friend that you visit in a nursing home, and some of those might be on private pay. And that could be $8,000, $9,000, $10,000 a month. And a lot of people think they have to spend down everything before they qualify for any government benefits. So one of the topics, Attorney John Frazier is with me. Good morning, John.
Good morning.
John has been with the firm since 2001. His primary practice is Medicaid. So he'll do all the Medicaid applications and everything. For many of our clients over the years, he's had thousands of cases. John has a BA in economics, an MBA from Virginia Tech, a Juris Doctorate, a law degree from Toledo University, and LLM, which is a master's in tax over top his law degree at the University of Florida. John's whole wall is filled with diplomas and educational achievements. And he spent a lot of time in school, as you can tell. But he's really a great asset for the firm and handles all of our Medicaid VA benefit cases. So, John, a lot of people think you have to be poor to qualify for Medicaid. So a lot of people have assets and they're worried about having to spend them all down and have nothing. So let's talk about the myth that you have to be poor to qualify for Medicaid first.
Well, that's a really huge myth. Here in Florida, we have some very powerful asset protection laws. My typical case doesn't involve millions of dollars, but my biggest case was last year, and the case involved over $4 million in assets. So the primary asset limits here in Florida, if you have a married couple, you have a $2,000 asset limit for countable assets for the Medicaid applicant. And the spouse living in the community, the asset limit is $128,640. However, we have these very powerful asset protection rules here in Florida. So virtually all of my clients are going to have be over the asset limit, especially if they're married. If they're unmarried, only allowed to have a $2,000 asset limit. So virtually everybody's got more than $2,000. So we have some very, very powerful tools for restructuring the countable assets.
John, let's talk about what a community, let's say you have a nursing home spouse and you have a community spouse. You have one spouse who's going to stay in the community and one goes into the nursing home. Mm-hmm. What can a community spouse keep and the other one still qualify for Medicaid?
Well, the law says that the spouse in the community can keep $128,640. However, we have two strategies here in Florida, in particular one called spousal refusal. And what that involves is we take everything over $2,000, in excess of $2,000 for the Medicaid spouse. We transfer those assets to the spouse in the community. And then most of those spouses are going to be over $128,640. If we have hundreds of thousands of dollars or millions of dollars, I've done at least 5 cases over $2 million. I've done at least 20 cases over $1 million in countable assets. We use this strategy called spousal refusal. There's a couple forms that need to be signed. The Medicaid applicant absolutely must be below $2,000 in countable assets prior to submitting the Medicaid application. But by using the spousal refusal strategy, there's a complete disregard of all of the countable assets for the community spouse.
All right, so in addition to spousal refusal and $128,000, what are some other assets the community spouse can keep free from and still qualify, the nursing home spouse still qualify for Medicaid?
Well, the Florida homestead is going to be exempt. Now, if it's an unmarried person, the Florida homestead is up to $595,000. But if the spouse is living in the community, there's no asset limit for the spouse. So the spouse could literally be living in a $5 million house.
On my cell phone, you cannot.
One automobile is exempt. Other automobiles that are over 7 years old or older and not luxury vehicles are all exempt.
savings.
Another primary exempt asset would be an irrevocable funeral service or cremation contract. The household items are all exempt. Furnishings inside the house are all exempt. So there's a number of exempt assets.
All right, and a lot of people don't know anything about exempt assets, and they've always heard, like I started the show, thinking they have to spend down and lose everything before they qualify. Well, a community spouse gets to keep a lot, as you can see. They keep the homestead, 128,000 plus, a car. So a lot of things that a community spouse can keep. So let's talk about if a person, let's say a single person, John, goes into a nursing home and they're not married, what can a single spouse, what kind of exempt assets do they have?
Well, as we mentioned, the Florida homestead up to 595,000. In recent years, I really don't see homesteads in excess of that amount. It would be very rare if we do. So typically the homestead is going to be exempt in really all my cases. One automobile is going to be exempt, going to be allowed to have $2,000 in the bank account. Funeral service contract. We have another thing called a burial savings account. So this is in addition to the $2,000 asset limit, the Medicaid applicant and a spouse are both allowed to have another bank account for $2,500 each called a burial savings account. And all it is a savings account that says their name and then burial savings account in the title. We list the beneficiary on there, so if anything happens to either spouse, we're going to have a beneficiary on there to avoid probate. And we've just sheltered another $2,500.
Okay, let's suppose a single person in a nursing home doesn't qualify. On the face of things, they don't qualify because they have too many assets, too much income. So let's deal with each of those. There are 3 qualification points on a person. They have to be able to pass or fail a health test. Why don't you talk about that briefly?
Sure. So there's 3 basic criteria. And the nice thing about this practice area, I've done in excess of 3,000 of these cases. We have 3 relatively simple rules. And we know that we're going to get our Medicaid case approved if we can put a check next to those 3 rules. The first one is a healthcare criteria. The state of Florida, upon the Medicaid application being filed, will send a caseworker from the Department of Elder Affairs actually to visit the Medicaid applicant at the nursing facility. There have been some changes, I think, since COVID started in March or so. That they're doing more medical review of the documents rather than face-to-face visits in every case because of COVID-19. But also the caseworker will review the medical records and establish that the person has a medical need to be in the facility. This is a very expensive program for the government to run. On average, about $7,500, maybe $8,000 a month in taxpayer money is spent on this program. So it's incredibly expensive for the state and federal taxpayer. So the government wants to make sure that every person applying for this program has that medical need to be in the nursing facility.
Okay, let's talk about if they have too much income, monthly income to qualify. What can be done so we help them qualify even though they have too much income to start with?
Florida is called an income cap state, and about half of the states in the United States are called income cap states. The other states are referred to as medically needy states. Here in Florida, the cap this year is $2,349 per month. Now, the state of Florida doesn't just pull that number out of thin air. They actually take a number, which is supplemental security income, which is a type of disability. So SSI disability, if you take that number for 2020 and you multiply it by 3, that's going to give you $2,349. So each year, when that number goes up, our Florida Medicaid will go up, our Florida Medicaid income cap will go up. And if the person exceeds that cap, we need what is called a qualified income trust, and about 25% of our clients need that trust.
All right, so we can't do much about the health test, but we can adjust the income so a person qualifies. Suppose they have too many assets to qualify. What can we do for planning on those?
We have an extensive array of strategies here in Florida. We're actually very, very lucky. I've had cases where we had $500,000 in countable assets, and we can get a person like that on Medicaid. So I'm going to talk about the basic strategies. There's a whole number of them which are based in Florida law. So these numbers are both in Florida law, case law, and the DCF policy manual all support these strategies. The first one is called a personal services contract. So if you have, let's say that you have 100,000 Medicaid applicant unmarried with $100,000 in the bank account, to simplify the case, and let's say they have a $250,000 homestead. So we need to do something with about $98,000. So I'll use that sort of simple example, which is fairly typical of what I see in my practice area. So this first strategy is called a personal services contract. So we are allowed to pay a lump sum of money right now to one or more caregivers involved in the person's care. So oftentimes we'll see the power of attorney, spending hours and hours every week taking care of their family member in the nursing facility. So this contract is based on age and life expectancy. So the contract must be in writing. It must be equal to or less than the person's life expectancy under the actuarial tables. And so let's say that you have a 75-year-old male. We do a contract for 3 years. We pay out $98,000 to the family caregiver. That would be permissible under these rules. And so we've just sheltered what we need to shelter very quickly by using this personal services contract and transferring the $98,000 to the power of attorney caregiver. The problem, though, is that that's a taxable event. So that person then has to claim $98,000 on their income taxes. So for that reason, we typically would not do the personal services contract for all the money. Oftentimes, we will use a personal services contract for some of the money in almost all my cases, but we have a whole list of other strategies that we use to shelter that $98,000.
Okay, I want to talk about another common myth that people have. And one is, well, I'm put my son's or daughter's name on an account, or I shifted all of my accounts so I don't have any assets. So they've made a pretty large gift in a lot of cases, thinking they can gift one day and qualify for Medicaid the next. So let's talk about gifting, John, and even putting someone's name on an account is considered a gift. So what are the Medicaid rules about gifting?
Well, Medicaid said we have what is called a 5-year look back. So in Florida, we have something actually started in federal law called the Deficit Reduction Act of 2005. It went into effect in Florida in November of 2007. Prior to that date, we had a 3-year look back on transfers. That law increased the look back period to 5 years. So let's go back to the example where we have $100,000 or $98,000 we're trying to shelter. And we have this scenario happen quite a bit. We'll have somebody contact our office and they'll say, well, I just transferred everything to myself because I heard there was a $2,000 asset limit. We applied for Medicaid and the state of Florida said that you disqualified your mom for Medicaid for 10 months. That's because we're not allowed to just simply give assets away to get Medicaid. I think, if we were allowed to do that, everybody would be on Medicaid and there really wouldn't be any Medicaid planning attorneys because everybody would just give their assets away and everybody would be on Medicaid. So we can't give those assets away. It's a crime if you don't disclose it. They're going to catch it anyway if you just did it. So we're not allowed to give the assets away if you're an unmarried person. Now, if the person's married, however, we are allowed to transfer an unlimited amount of assets to the community spouse. So that goes back to that spousal refusal strategy that I was talking about. That's how I can literally get multimillionaires on Medicaid.
All right, so lots of different interesting things you can do on Medicaid planning. A lot of people wouldn't just think about on their own. So again, if you have a person that a family member, a spouse or a friend or a neighbor or somebody, maybe you just visit them in a nursing home and you hear them talking about, well, this is so expensive and I'm going to run out of money. Hey, we can usually protect the money, protect the estate, maximize government benefits by some of these planning strategies that John can use, or any Medicaid attorney. I'm not here just to solicit business. We're here to educate you on all the options that are available. We'd certainly be glad to help anyone who doesn't have an attorney that needs some help. And John also gives a free consult to anyone who has a personal situation they'd like to talk about privately. And maybe you'll learn enough today to realize there are some opportunities out there to take advantage of, to maximize government benefits and protect and preserve your legacy. I mean, you work hard for your estate. Whatever you have accumulated, you worked hard for many years. And a lot of people would tell me, Joe, well, you know, I just don't feel right about doing all this planning, kind of adjusting assets, putting them in different categories to qualify for government benefits. I thought that was only for poor people. My thought, I've had mixed thoughts through the years about this, but my job as an attorney and John's job as an attorney is to advise you of all the planning options that you have. And the option that you choose is your choice. All John and I do is give you the information to make a choice from. So we're not here saying everybody must do this. We're here just to explain the options that are available to anyone that wants to apply for Medicaid. Personally, everything that we do is disclosed to Department of Children and Families, who would approve the Medicaid application. There are no secrets that we do. There's no secretive things that are criminal or wrong. We disclose everything we do in our Medicaid planning for our clients. All has to be disclosed. So we're fully in front of all that, fully do that. I personally never question a person's judgment on what they choose to do. And I think you're wise to know what all your options are and make a decision from there. We've had a few cases, I'd say they're in the minority, a few cases of persons as well, they've got money and we just want to get the very best care we can and we don't mind private pay. So John, how would you comment to the difference, this comes up all the time, how would you describe the difference in care of a person in a nursing home that's on Medicaid versus a person in a nursing home that's on private pay?
Zero difference. The facility does not care how they're getting paid. It would be a crime for them to discriminate. The people who work on the floor, the nurses, the CNAs, they don't care how the business is being paid. They're there to do their job. They're licensed, and so it's never once been an issue. Now, what could be an issue, though, is going to a facility that's got major problems. All of the facilities take Medicaid in Pinellas County and probably pretty much statewide. So I think the key thing is to make sure you're placing your family member in a facility that's got a good rating. So that's critically important. Going back to the other issue that Joe was talking about in terms of, you know, the potential ethical considerations of this, I think there's two important things to think about. Number one, most of our clients all of Joe's clients are going to have an estate plan. So the Medicaid applicant thought before they went into the nursing facility, naming the children or whoever, the church, whoever they want to be the beneficiaries, you're never going to see a nursing facility named as a beneficiary in a trust. I've never seen one anyway, or a will. So the person in the nursing facility oftentimes has already made a decision that they want their estate to go to their beneficiaries. So I think arguably the power of attorney, who is typically who we're dealing with, may have a fiduciary duty to that family member to protect those assets rather than to spend those down on the person's care, because it's that person's money. It's not really the power of attorney's money, and it's not really the power of attorney's decision. So I think that decision has already been made by the Medicaid applicant if they have an estate plan. I think the other thing that you want to think about is, let's say that somebody calls me and they have $1,500 in their checking account, they have $1,000 in Social Security, and they've never had any savings. Well, that person never paid into the system to the same degree that somebody who has several $1 million. They paid taxes their whole life, contributed a lot. They paid more into the system than a person who never saved anything up and who would already be eligible. So I think that's another thing to think about. You know, you've paid a lot of money into the system, and now it's time to get paid back a little bit, I think, also.
Let's talk about some things that people should do, like a funeral contract, and what that implications are on that as far as Medicaid planning.
I think that makes a lot of sense. Most of my clients are over the age of 65 now. Just had a case approved yesterday, actually. Client, 51 years old, disabled under Social Security. So we do have younger clients, and over the years I've had clients with head injuries, early onset Alzheimer's. So, but anybody, if they're going to meet that medical criteria, if they're under 65, disabled under Social Security, for example, over 65, again, most of my clients are over the age of 65, but I would say probably 75, 80% of the clients in that age range have at least thought about and oftentimes made some plans regarding the funeral service contract or cremation contract. The remaining 20%, we tell them, typically they are going to purchase a funeral service contract or cremation contract as part of this planning, because any amount of money that you spend on that contract, funeral service or cremation, is going to be treated as a non-countable asset as long as you make it irrevocable, which means that the Medicaid applicant can't turn around and cash it in and get the money back right after they apply for Medicaid. I had one client spend $25,000 on those services. It's more typical to see between 2,000 and maybe 7,000, but that's a very good planning strategy, I think, to do that.
What about using money in a person that has to make home repairs, like a new roof and things like that?
I think that's an excellent option. I had one client a number of years back literally spent $90,000 on repairing the homestead. So they put a new roof, new AC unit, $7,500 for an AC unit, completely remodeled the house, landscaping, furniture, appliances, literally spent $90,000 on repairing the house. We simply submitted all the documentation to DCF. They didn't even ask us a question. As long as we have that documentation, they don't care. As long as that we can establish what we've done with that money, that we haven't written a check for $90,000 to a child to give the money away. That's the main thing they're looking for, is for people trying to give the money away to the children or other people that are not spouses.
So John, let's say a person will spend a lot of money improving their home. That's non-countable spending, so that just reduces the size of the estate that would disqualify them. Let's suppose they do all of the things we've talked about. How expensive can a car be if a car is exempt? Is there a limit?
It says one car of any value. So now I try not to really push the limits too much on this, but I have had some clients buy $70,000 brand new Lexuses, Mercedes-Benz. I've even had a few people buy collector's cars because you're actually allowed to own a collector's car. So, and the Medicaid applicant doesn't even need to have a valid driver's license. They're actually allowed to own a car without a driver's license. Now, you can't get it insured without a driver's license, but you can still own one. So one car of any value, and then extra cars 7 years old or older and not luxury vehicles. So you could literally have, 10 Toyota Camrys, year 2010. They'd all be exempt.
Okay, so you do all of these things and you still have some money, John, and somebody suggests, well, why don't you buy a rental home? Because they heard that didn't count as an asset. How does that work?
We've done that on numerous occasions. So that is typically in a situation where we have more than probably $200,000. It could be less. But if we have something like $500,000 for an unmarried Medicaid applicant, there's really, other than buying a homestead, we can talk briefly about that too, but you see, once the person's already in the nursing facility, they can't go out and buy a homestead, and it won't be exempt. There was an attorney who actually tried that. The person was already in the nursing facility, never lived in the homestead, bought a homestead, and the state of Florida said, you have to have an intent to return to that house in order for it to be exempt. If you never lived there, you can't have that intent, and they denied the case. They were able to get it fixed by, I think, listing the property for sale. That's a way that we can make property exempt also. But going back to rental property, if we have $500,000, we really don't have any choice. If the person's already in the facility, if they're not in the facility, we can consider the homestead. But almost all of my clients are going to be in the nursing facility. So rental property is the only way we can shelter large amounts of money like that. So the way that we do that is there's really 3 variations. We can just contact a real estate agent and say, well, we need to purchase a $300,000 property with a renter in it. They're out there, and there's a lot of real estate agents that are happy to help. So that's one way we can do it. Another twist on that, we've actually had the family member sell their homestead to the Medicaid applicant and then start paying a fair market value rent. That also works. We just have a lease and that works. There's a third option. There's a company out there that was founded by 2 board certified elder law attorneys who I know personally. If you hire me, we will also discuss that option with you, and they work only with attorneys who are looking to shelter assets for Medicaid applicants. And that's all that they do. They have a 100% success ratio. So some people, when I say rental property, well, they'll say, well, I want nothing to do with being a landlord. I tried that, 20 years earlier. It was nothing but a headache. This company takes care of all the landlording issues and the rent collection issues. So the Medicaid applicant and the power of attorney are not the landlord in that situation.
All right, so I'm going to talk to John a little bit about VA benefits versus Medicaid benefits and what the better plan is if you have that option. And right after that, we're going to go. I said we talk for about maybe a half an hour to give you as much information as we can. And then after we talk about VA versus Medicaid, and both of those, we're going to go to the chat room and take your questions. I see 4 or 5 questions already lined up there for John and myself. So now would be a good time if you have a question. We'll do probably the chat room first, and then we might take a few questions from the audience live if we have time. So go ahead and send us a question on the chat room if you would like. And John, let's talk about if a person comes to you and said, hey, I want to do some VA planning. What's this aid in attendance? And should I do VA planning if it looks like we might be headed into a nursing home in a couple of years? So what would your options be there?
Well, this also brings up another Medicaid issue, which is very, very important. This is something that I think a lot of people are not aware of. In Florida, we have Medicaid for both nursing, assisted living, and in the community. But here in Florida, we have a waiting list for assisted living Medicaid. I also have extensive experience in dealing with that waiting list. So if you have a family member currently in an assisted living, the answer is there's going to be a waiting list, but with proper legal guidance, we can get you potentially a higher score on that waiting list. The way that this waiting list works is it's got a 1 through 8 scoring system. The form is called a 701S document or scoring tool or screening tool. And what we're looking to do is to get a score of 5 in each one of those cases. Categories 6, 7, and 8 are very rare categories. One is called aging out, which involves younger people. We have adult protective services, and then we have imminent risk. So those are not really things that I see in my practice area. So we're really talking about 1 through 5. If you answer these questions properly, you can greatly increase the chance of getting a score of 5, and then your name rises to the top of the waiting list. And leading into the VA discussion, over the years, I've had a number of clients receive both Medicaid and VA. That's primarily in the assisted living context. And so what I'm talking about, the VA is a whole nother topic that we could talk literally for hours on, and we've also written a book on that topic. So you have 3 different, to break it down very, very briefly and simply, we have 3 different sort of systems that are related to VA or military payments. You have military retired pay, which is paid for by DFAS, Defense Finance and Accounting Systems. That's just like Social Security or regular pension. Then we have 2 VA types of disability programs. One is called service connected and one is called non-service connected. So service connected, and I've had some great, especially World War II veterans, had one client, 60% service connected. He was actually hit by a German artillery shell in France. And 60% service connected, and that's the threshold for free nursing home care. So if you're 100%, you have more options, but the threshold is 60% service connected. However, most of my clients don't have a service connected disability, and that's where we talk about the 3rd program, which is non-service connected pension, aid and attendance, it's also called, or VA pension. So this is really helpful in the assisted living context. A veteran who qualifies is eligible for $1,911 a month. And many of our clients are actually qualified for that just by virtue of their military service, and they have no idea about this. So if you've been a military veteran for 90 days or more, active duty, honorable discharge, prior to about 1982 or so, there's a very good chance that you would be eligible for this pension if you were in an assisted living facility. Here's another thing that completely surprises people. The surviving spouse of that veteran who is eligible is also eligible if her spouse passes away, and that pension is $1,228 a month. So this is really amazing for some of my clients that they're actually eligible for this pension from the VA. They had no idea. They weren't injured in the military, and oftentimes their surviving spouse is eligible for that pension. And that's very, very helpful in the assisted living context. And one of the big differences between assisted living and skilled nursing care is that the Florida Medicaid program is going to pay for all of a person's expenses. All of their expenses will be covered by their income. So a very, very simple example. Let's say that you've got an unmarried person with $1,000 a month in Social Security, and that's their only income. They go to a nursing facility that's charging $15,000 a month, and you get them on Medicaid. The cost of that facility is $1,000 minus $130, the personal needs allowance. So you're talking about saving, close to $15,000 a month in that scenario. On the other hand, one of the differences with the assisted living Medicaid program is that the Florida Medicaid program only pays between $1,000 and $1,400 a month in excess of the Medicaid recipient's income. So let's say that person has $1,000 a month in Social Security. Florida Medicaid program is paying $1,400, and that's $2,400. But let's say that this facility charges $4,000 a month. This is where that VA pension can be critical, because if you have a surviving spouse, you get an additional more than $1,200 a month, which will pay that differential in an assisted living facility. So that's really the context where I see the VA benefits be very, very helpful, is in the assisted living context. And I know that's a lot of information, but...
All right, so after John did that, I could tell you that if you would like to ask John some questions, he'd be glad to answer, spend time with you on one-on-one on the phone to go over maybe what some of your benefits would be and what your best choice would be. So John, why don't, before we go to the chat room and take a few questions, we got 7 questions lined up in the chat room right now. Why don't you give your contact information, phone number, how they would contact you directly?
The main office number is giving you our contact phone numbers and information when we lost the internet connection. The main office number is area code 727-586-3306, extension 104. My cell phone number is 813-431-3193. My email address is john, John, at attypip.com. And Joe's email address is joe, Joe, at attypip.com. So now we'll start opening it up for questions. And Troy is going to assist me. Troy Pippen is going to assist me with that.
And whoever typed in the chat, they'll have to resubmit their question. We had lost internet for a few minutes, so we apologize about the interruption in the meeting. But if you had typed a question in the chat box, go ahead and type it in there again. Also, if you'd like to unmute yourself, you can do that. Instead of typing a question, you can unmute yourself and just speak to us live.
Sure,
I have a question. This is Marilyn Stover, and I am the spouse of a deceased veteran.
Oh, I'm sorry. Yeah, the volume came up. So if you could repeat that question.
Okay, I am the spouse of a deceased veteran,
Okay.
and I do not receive VA.
Hello?
Can you hear me?
Oh, yeah, I can hear you.
Okay. I do not receive a pension. Does that have any effect on a possible nursing home VA?
Well, this is something that we haven't really spoken about, but here's the way that it works. If a person is unmarried and they're in a nursing facility on Medicaid, they're only eligible for $90 a month for this VA pension. So that's why when I was explaining, it's primarily for assisted living Medicaid, and what you have to have in order to get this pension, and it's not really actually a pension like Social Security. It's got some similarities, but the way that you want to look at it is it's actually a reimbursement for unreimbursed medical expenses. So if you're an unmarried person in the nursing facility, your income is going to cover all of your medical care. And I had mentioned the $130 personal needs allowance.
Yes.
You're also allowed to have that, keep $90 if you've got the VA aid and attendance. And
Okay.
sometimes we'll have somebody who's in an assisted living facility, and let's say that they have the VA pension, and so surviving spouse getting $1,228 a month. Once we apply for Medicaid and those benefits are approved, under the VA rules, the VA claimant, it's typically the power of attorney, because the person in the nursing facility typically cannot do paperwork and things like that. You have to notify the VA that you've got the Medicaid benefits, and then the VA program will actually drop the VA aid and attendance down to $90 a month. I know it's a little bit confusing, but that's the way that you want to think about it. If you're in an assisted living, that's where the VA pension can really help you. But if you're an unmarried person in a nursing facility, you're only eligible for $90 a month. And
Thank you.
the other thing is, I have many free resources here in Pinellas County and actually in Hillsborough, and they're called veteran service offices. So many of my clients are already financially qualified for these programs, and if they don't need an attorney, I'll tell you that, and I'll refer you over to a veteran service office, and they will take care of all your needs for no charge. So that's
Thank you very much.
Yeah,
Yes,
sure.
that's what I want. So I'll email you and ask you for that, okay?
Yeah, absolutely, yeah.
Okay, thank you for your help today.
Sure. What's the next one? Can a couple open a burial savings account prior to anything happening to the couple? Yes, the answer is yes on that. I don't know that you need to do that for a couple different reasons. It's very easy to open these burial savings account, and we're typically going to have a properly drafted power of attorney at the beginning of our case. And so the power of attorney can actually take the power of attorney to the bank and open the burial savings account on behalf of the Medicaid applicant when the person's already in the nursing facility. So the answer is yes, it can be done, but I would say normally that's not really something that we use for a Medicaid pre-planning strategy, because it's a relatively small amount of money also, only $2,500 for each of those. But the answer is yes on that.
All right, so I'm back. I'm sorry I had to leave there for a few minutes. Went to do a signing and got caught a little bit. So what question were you?
On the top there is the long-term care.
Care, you just took that one? So the next question was, how long does it usually take for a Medicaid case to be approved?
The general rule historically is the DCF has given us 30 days and then an additional 30 days. So it really depends on the size and complexity of the case. I actually just had one case we applied in May. Person actually passed away. We had passed away actually a month and a half ago. And I finally heard back from DCF legal counsel yesterday, and we're talking like 4 months now, due to a variety of different delays at DCF. The pool trust documents were not sent over to the DCF legal office until August, and I've been not given an explanation on that. But in that example, we had a relatively straightforward case, and it took 4 months. We're still going to get our benefits to the first day that the person was eligible up till his date of death. But that's an example of DCF taking a very long time for a very simple sort of matter. But the general rule is it's a 30-day rule, and then up to 60 days. Historically, if you go past 60 days, you have to reapply. Now with the COVID situation, they're giving potentially up to 120 days now. But really, it's typically the more complicated cases and the spousal refusal cases, especially in the central region of the state, DCF central region. They're notorious in the DCF central region for taking a long time. Here in our region, they're generally pretty efficient. The state of Florida has a number of different regions. So depending where the person is in the state of Florida, it's going to be assigned to that region of the state. And I do statewide, so I've got clients in Miami, Orlando, up to Tallahassee, and everywhere in between. And those cases are going to be assigned to different DCF offices. Some DCF offices, like here in the Pinellas County area and Hillsborough County, much more efficient than the DCF central region. So it's kind of a case-by-case thing, but DCF does actually have rules, but a lot of times DCF doesn't always follow their own rules.
John, someone wants to know here, how do you charge for your fees for these type services?
We charge a flat fee based on the size and complexity of the case. So we don't have one size fits all because we have client cases and clients which are all over the spectrum. In some cases, we've got a client who has $500 in their checking account and they just need a qualified income trust. They don't need asset restructuring. So if we're just going to do the income trust and the nursing facility is going to do the actual Medicaid application, we're just going to charge for the trust, and that's going to be a pretty low fee. We also use a sliding scale even in a situation like that. But if we've got a $4 million Medicaid case, the fee is going to be significantly higher than someone who is basically already impoverished. So it's we don't bill by the hour; it's a flat fee for everything.
Couple wants to know if they can open a joint funeral savings account prior to anything happening to them.
Well, this is one of the things that can get very confusing. We spoke about a lot of different things, but there's a difference. They're actually different. A funeral service contract or a cremation contract is actually with a funeral service provider, and they're all over the place around Pinellas County. A burial savings account is actually just a bank account with a bank. So you take the power of attorney goes to the bank with the power of attorney. If it's an unmarried Medicaid applicant, just opens, let's say it's Jane Smith is the Medicaid applicant, just a fictitious name. It would say Jane Smith Burial Savings Account in the title, and a beneficiary will be listed. So the burial savings accounts are not joint. If it's a married couple, there would be one, so it would be Jane Smith and Joe Smith, if that's the name of the husband, for $2,500 each. That's completely different from a funeral service or cremation contract, which is with a funeral service provider. So they're very different. I know it's a lot of information, but they're very different things.
John, how long does it take to approve a Medicaid case?
Well, I just spoke about that briefly before. The state of Florida automatically gives 30 days from the date of the application. Then if it goes past 30 days, then they give you another 30 days for 60 days. And historically, they would say, if it goes past 60 days, you have to reapply. Now we have up to 120 days because of the COVID-19 problems. So, and as far as, and I had explained that some regions of the state are much more efficient as far as the DCF offices are concerned. Here in Pinellas County, Hillsborough, very efficient as a general rule. Historically, however, DCF Central region has not been efficient. That would be in the Orlando area. So it's case by case thing.
John, so dad is 98 years old. Daughter insists on keeping him at home. Mm-hmm. Can she get financial help?
It's possible, but again, we have financial criteria. So I can evaluate the case. If the person is not in a facility, not in a nursing facility, we're talking about a waiting list scenario. So what happens in that situation, we can be hired to do that. It's also potentially possible to do it yourself, but there are a number of what are called area agencies on aging, or AAA organizations throughout the state of Florida. So in order to get on that waiting list for assisted living or community-based program, you have to reach out to the AAA office here in this region and get put on that waiting list. And the form that is used for that is the 701S screening form, which I had mentioned earlier in the presentation. Our office also does that if you'd like to contact us about that.
All right, so the question is, my mom has a revocable trust and all of her rental properties and assets are in the trust. If she has to go into a nursing home, does the trust protect her? Well, all of those assets in a living trust are countable assets. So I'm not sure they are protected from probate guardianship and not protected against qualifying for Medicaid just because they're in a living trust. However, mother can do all of the things that John has discussed with the rental homes. Might not count as an asset.
It's already going to be exempt, and the Florida homestead's going to be exempt.
The homestead's exempt, and some of the other cash assets in the trust can be changed to non-countable assets, like one of the things might be a personal service contract there.
And we see it all the time.
So the trust, I tell most of my clients, the trust is a great starting point for estate planning. It avoids probate. It does the same thing a will does, but avoids probate, avoids guardianship, makes it quick, easy, fast, efficient, and private. The whole Medicaid planning process starts when the person goes or knows they're going to go into a nursing home. And then all of the other strategies, that John has talked about in pretty good detail today would then be accomplished by the power of attorney and the successor trustee working together. So that would all take place a little bit later on when you know mom's going to go into a nursing home in this case. And the question goes on, if not, can the name on the trust be changed to protect assets after 5 years? The trust could be converted to an irrevocable trust, which would trigger the 5-year look-back period. So the answer to that could be yes. Whether or not that would be the best planning strategy or not would probably take a few meetings and some decisions to be made, though, before that decision would be made. And would it be protected as long as it was put in someone else's name? The 5-year, if you put something else in someone else's name, that generates the 5-year look-back period. So, John, if you have long-term health care insurance, can you still apply for Medicaid is the next question.
Yes, and we see it all the time. Unfortunately, many of these policies do not pay enough to cover the cost of the person's care. A dollar amount that I regularly see is $100 a day. So that's $3,000 a month. We have a nursing facility here in Pinellas County that charges $17,000 per month. So that $3,000 is not going to cut it. So we are regularly seeing people with long-term care insurance apply for Medicaid. There's one sort of subtle distinction. If you were to ever hire us, we would talk about it in more detail. But there are two types of long-term care policies. One's called an indemnity policy, which is treated like income for income trust purposes. So that $3,000, if it's an indemnity policy, will then put the person over that Florida income cap that I spoke about, the $2,349 a month cap, and it actually would create the need for a qualified income trust if we have an indemnity policy. The other type of policy is called a reimbursement policy. So if that pays $100 a day up to potentially, cover $100 a day, and it's called a reimbursement policy, the state of Florida is going to say that is not income and we will not need an income trust. And the way that we verify that is we typically just get a very simple letter from the insurance company stating what the dollar amount is and whether it's the state of Florida will see the word indemnity or reimbursement. And as soon as we see one of the other words, we'll know whether we need the income trust or not. But I do see that all the time.
All right, the next question is the book that you're sending to our home for attending the seminar today, will it cover topics in more detail to include VA benefits? The answer to that, John has another book on just VA benefits. So today's topic was more or less Medicaid benefits, although we did talk about VA benefits. I'm sure, though, if John, you make an appointment to discuss VA benefits with John, I'm sure he'd be glad to, since you asked, to give you a free book. Though.
Absolutely.
Yeah.
No problem.
So make an appointment with John, though, to discuss your VA benefits concerns, and John will give you a free book at that meeting. Do you have to do this, meaning what we've talked about today, before you go into the nursing home, or when you're in a nursing home, can you do it, or do you have to wait 5 years before you go in?
Well, most of my clients are already needing care. They're actually already in the facility. What I would say is the number one most important thing at the beginning of every single one of my Medicaid cases, especially if the person is not married, is do we have a properly drafted power of attorney? And I can tell you about 20% of our new clients either don't have a power of attorney or they have a power of attorney that has some sort of major problem with it. In 2011, it's not a new statute anymore. We're talking about 9 years now from 2011, but to this day, I continue to see powers of attorney that do not comply with the 2011 power of attorney statute, and I know that Joe sees that problem all the time. So the number one thing to take care of for everybody, and that includes, younger people not even thinking about this topic, is to make sure that you have a good power of attorney document. Our office charges a very low fee for that. And actually, if you hire us for Medicaid, that's typically included in our services for no charge, the document itself. So.
All right, so we have about 5 more minutes in the program before we end at 11, and we're out of the chat room questions. If you have a question you'd like to ask live on the air today, go ahead and raise your hand, and if I can see you, I can't see everybody. We have quite a few people online here, but if you raise your hand and I can see you, I'll recognize you, then you can unmute yourself and ask your question. Can you have, okay, let's go to Trevor Colby. Can you unmute yourself? You need to unmute yourself. I can't, Trevor, I can't hear you. So can you unmute yourself if you can hear me? And here. Trevor, you have to unmute yourself. It's down in your left corner on my computer. Still can't hear you. Still got the mute button on. Okay, so. All right, Trevor, there you go. Okay, you unmuted yourself.
Okay, yeah, I've seen a question in the chat room that I don't think has been answered, and it says, why would you want long-term healthcare if you can get Medicaid? Or did I miss it?
All right, great question, though. That's a good question. I'm glad you brought it up. John?
Well, I think there's a couple of different reasons, and I know that Joe has addressed this many times over the years with clients. Well, one thing is, we have some very favorable laws here in Florida right now, but we've seen our deficit skyrocket, in the past 20 years, and with COVID-19 and all this government spending continues to escalate. So at some point, arguably, our government may not be able to pay for all these programs, and I think this waiting list that we have with the assisted living Medicaid program is yet another example of our government simply not having enough money to pay for these programs. So I really don't tell people not to get long-term care insurance, because let's say 10 years from now, all these asset protection strategies go away and you didn't buy long-term care insurance. So it's really a judgment call, I think. My mom has long-term care insurance. She's up in a different state. And that's been a good decision for her. But here in Florida, it seems like most of my clients, unless they're in an assisted living facility that's charging $3,000, $4,000, $5,000 a month, we have to apply for Medicaid for them if they're in a nursing facility, because it's typically $100 a day. Sometimes it's $150. That is just not enough to pay for these nursing facilities. The average cost is about $9,500 per month.
Yeah, Trevor, I get that question all the time, actually, particularly when we talk about it like we are today. And the question sometimes when they come in my office, do I still need to buy long-term care insurance? This is before they would buy it. What would you recommend if I buy it or don't buy it? I said, well, I could never recommend you don't buy it, but I could not guarantee that. And they say, well, if I can do all of these things you talk about on getting Medicaid, why would I need it, is the question before they buy it. And I said, well, I can't guarantee all these things will be available. Medicaid laws change, seems like every 6 months to make it harder and harder to get Medicaid. So you take advantage of what you can when the time comes. If you can afford long-term care insurance, I can't tell you not to buy it, because I think it's a good planning strategy to have it. But a lot of people wait too long, and they're too elderly, and the premiums are much, much higher when they decide they might need it, and then they can't afford it. So then they're asking me the question, should I do it, pay all this money? And I have the same answer. Well, I can't recommend you don't do it, but if you don't do it presently and would try to qualify for Medicaid, then you could. So it's one of these. It's a great question, though, and I get that all the time.
Yeah, can I just answer? Although I didn't ask the question, it actually does apply to me. And I've been paying into Mutual of Omaha thing for about 11 years, I think. So I just think I'll continue to pay it for now.
Yeah, well, that's kind of a personal choice, so we can just discuss options with you.
Yeah, thank you very much.
All right, anybody else have a question? You can wave at me a little bit. Okay, let's go to Linda. Linda, you can unmute yourself, though. In the left-hand corner, there should be a little unmute button. There you go.
Thank you. I don't know whether this question pertains to Florida or not. My parents were elderly and lived in Massachusetts. And my father went into a nursing home. But prior to that, she was considered a frail, elderly occupant of the house. And I went to senior services for her, and they were going to try and put her on Medicaid to get help into the home for her. Do we have such a program in Florida like that?
Yes, there are definitely community-based services, but the person starts out on a waiting list, and I've had several of those cases this year, and their name came up on the waiting list, and then we restructured the assets to bring them to less than their $2,000 asset limit. So we definitely have that program.
Yeah. What happened after that my father went into a nursing home, so she was disqualified because we put him on Medicaid. And
Okay,
everything went into her name to keep him on.
okay, and
They call
that was in
that-
a different state, right? A different state? Yeah.
Massachusetts.
Yeah. Well, here in Florida, we can get both spouses on Medicaid, but there's a $3,000 asset limit. But I've had this a number of times over the years. Sometimes we'll have one spouse start out in the nursing facility, then 5 years later, something happens. And then we have to, sometimes they'll be in the same room, in the same nursing facility. And we have to bring the spouses together to less than $3,000. They don't double it up and give them $4,000. They only give them $3,000. And then it ends up being a Medicaid reapplication for the initial spouse who applied for Medicaid, and then a new Medicaid application for the spouse that just went into the nursing facility. But I've had that happen a number of times over the years.
Okay, good.
All right, so I'd really like to thank everyone for attending today's meeting. I'm going to invite you to listen to Ask an Attorney All About Florida Law tomorrow morning at 8 o'clock. Here in the Tampa Bay area, it's on 570, 910, 860 AM on your dial. I do that every week. I've done that for 36 years. It's a live show where I take questions, just like we've taken for the last few minutes. Longest running show in Florida. And if you'd like to contact our office, we have a toll-free number, 1-800-226-3529. If you're in the Tampa Bay area, the 727 number is 586-3306. Attorney John Frazier, why don't you give your contact information slowly in case
Sure.
anyone would like to take advantage of John's free consult. If you have a particular question on Medicaid or VA benefits, John will be more than glad to help you. There's no charge for that first phone consult. So
Same local office number, 727-586-3306, extension 104. You can call me. I have more than one cell phone, area code 813-431-3193 for Tampa. And for Pinellas County, 727-748-5374. My email address is johnjohn@atttypip.com.
and again, the local number is 727 number is 586-3306. If you go to extension 200, they can direct you either to myself or to John, depending on what your question would be. Make sure for all of those attended, get a free book. So make sure you have sent me your mailing address for that free book. I'd be more than glad to send that out to you. And thank you so much for listening. Y'all have a great, safe weekend and so on.
Yeah, one more thing I just want to say, if your first and last name was not labeled on your Zoom ID, or you were labeled as private user, or you had called in by phone to listen to today's seminar, then make sure that you email me, troy@attipip.com, and let me know that you attended so that you can receive the book in the mail. Thanks.
Thanks, Troy.
Thank
Y'all
you.
have a great weekend. Thank you.
Thank you very much.
Thanks a lot, Joe.
Joe.
Thank you.
Thank you, Joe, for your very valuable time. I was at your seminar 2 weeks ago as well. I do appreciate your free advice. And
My pleasure, really. I enjoy doing this, so thank you so much.
Have a good
and
day.
also you, John.
Thank you.
Thank
All right, bye-bye.
Thank you.